All right, so what prompted you to look into this?
Well, I represent Jim Rauckman. He's the former mayor of the village of Swansea. It had come to his attention that the village had used TIF funds to purchase a fire truck, and he hired me and another lawyer to look into whether or not that was an appropriate use of TIF fund under the TIF statute. And our research indicated that it was not. It's actually improper to use TIF funds in that way. And so we wrote a letter to the Village of Swansea Council and its attorney objecting to the use of TIF funds in that way.
And then what led to the Open Meetings Act lawsuit you filed?
Well, the village, having received our letter, wanted to discuss that letter in closed session. And in fact, it went into closed session to discuss the letter. It specifically said it was entering a secret session in order to discuss our letter, and that's a violation of the Open Meetings Act, because the Open Meetings Act mandates that public meetings are open unless an exception applies. Now, there is an exception for litigation, but litigation has to be probable or imminent. And we were not threatening litigation. We had no plans to litigate. We, on the TIF issue, we simply asked that the TIF fund be reimbursed by the village's general revenue fund. So we simply made a plea to the council and to the village that the TIF fund be reimbursed and that TIF funds not be used to purchase fire truck. We didn't threaten litigation. And because of that, the city simply was not allowed to invoke the litigation exemption to enter into closed session. In their use of a closed session to discuss our letter and the legitimate disputes about the use of public funds that we raised constitutes a violation of the Open Meetings Act, and our complaint challenges the public body's decision to go into closed session for that reason.